Welcome. Today, I would like to discuss the concept of an undertaking in EU competition law. Only undertakings are subject to competition law, so the application of Articles 101 and 102 depends on the reach of this concept. This also means that the concept of an undertaking is central to applying and relying on the competition rules. Establishing an undertaking may seem simple in theory, but it can be quite daunting in practice. The Treaty on the Functioning of the European Union does not define an undertaking, leaving it up to the European courts to interpret and establish its extent. To determine which entities constitute an undertaking and are consequently bound to comply with the competition rules, we need to review case law. In Commission v. Italy from 1987, the European Court of Justice ruled on the notion of an undertaking. The court introduced a distinction between the two functions of a state. In this case, the Italian state. On the one hand, a state could be exercising public powers, which is what we usually associate with a state and state functions. On the other hand, a state could also engage in economic activities of an industrial or commercial nature by offering goods and services in a market. To evaluate which of the two functions a state is acting in, we therefore need, on a case-by-case basis, to consider the specific activities exercised by the state and decide which of the two categories it belongs to. Thus, the following can be deduced about the concept of an undertaking. Firstly, the concept focuses on the nature of the activities carried out. Secondly, undertaking encompasses an entity engaged in economic activity. Thirdly, economic activity is offering goods and services on the market. The European Court of Justice takes a functional approach by focusing on the functions performed by a specific entity. Ownership or financing is irrelevant. Moreover, the concept of an undertaking is relative, as it focuses on the activity carried out by the entity in question. This means an entity may be seen as an undertaking for some activities, while others may not fall under competition rules. Another important judgment is the Hoffner and Elser case from 1991. In this case, the European Court of Justice stated that the concept of an undertaking encompasses every entity engaged in economic activities, regardless of the legal status of the entity and how it is financed. In the Hoffner and Elser case, the court ruled that the legal form of an entity is irrelevant when determining its classification as an undertaking. This means that the concept of economic activity should be broadly interpreted. Under this broad definition, all entities are considered undertakings regardless of their legal status. As a result, EU competition rules may apply to legal persons and individuals, state bodies, and other public entities. The fact that the entity offers goods or services without a profit motive does not preclude the entity that carries out those operations on the market from being considered an undertaking. In Motoi from 2008, the European Court of Justice held that offering goods or services without a profit motive does not prevent the entity that carries out those operations from being considered an undertaking. The offering is made in competition with other operators that pursue profit. Therefore, engaging in nonprofit activities does not change the fact that it may still be considered economic activity. What have we learned so far? We have learned what an undertaking is. More specifically, how it must be extracted from case law and how case law has applied a functional approach. This means that the concept of an undertaking encompasses every entity engaged in an economic activity, regardless of the legal status of the entity and how it is financed. Furthermore, the concept of an undertaking relies upon whether an economic activity is performed by offering goods and services on the market. As the concept of economic activities has no exhaustive definition, it is not possible to define a conclusive list of activities that are economic activities. The functional approach followed by the court focuses on the activity rather than the entity. The decisive factor was whether the entity conducts economic activity. The broad definition of an undertaking covers every entity regardless of legal status. This means that EU competition rules apply to legal persons and individuals, state bodies, and other public bodies. Subsequently, the focus will be on when state and other public bodies should be considered undertakings according to the competition rules. Entities involved in economic activities are subject to competition rules. However, entities that perform tasks in the public interest or exercise public powers are not subject to these rules. This exception is known as the public sector exception and has been established in the case law by the European Court of Justice. It is important to distinguish between situations where state and public entities act as the authority and cases where they engage in economic activities by offering goods or services on the market. This distinction determines whether they are subject to competition rules. One area where it can be challenging to determine whether individuals are considered as undertakings is platform work. According to the European Court of Justice case law, workers are generally not seen as undertakings for competition law. Workers are part of the undertaking with which they have an employment relationship. This means that Article 101 does not apply to workers. It only applies to the undertaking that employs them. Based on this interpretation, labor unions, which represent workers, are not considered associations of undertakings. Additionally, their decisions and agreements benefit from immunity under Article 101. In contrast, self-employed individuals are generally seen as undertakings conducting their business independently in the market. Consequently, they come under the scope of Article 101. Applying EU competition rules might impact platform workers' ability to engage in collective bargaining. Or perhaps more precisely, it prevents it. This is because platform workers are often categorized as self-employed, subjecting them to EU competition rules. The European Parliament has adopted the Platform Work Directive, aiming to improve the working conditions of platform workers. The directive includes new rules to address false self-employment, prevent workers from being fired based on decisions made by algorithms, and forbid platforms from processing certain types of personal data. The directive introduces rules regarding employment status, including a presumption of an employment relationship when there are indications of control and direction. The directive requires EU member states to establish a rebuttable legal presumption of employment at the national level to address the power imbalance between the platform and the person doing platform work. By creating an effective presumption, member states will make it easier to address false self-employment. The platform has the burden of proof, meaning that if it wants to challenge the presumption, it is its responsibility to prove that the contractual relationship is not an employment relationship. If you want to know more about the notion of undertakings in competition law and the issues of platform workers, I recommend this paper. It is well written and captivating. I have listed the cases I have referred to in the presentation here. That makes it easier for you to check them directly. Thank you very much for watching. I hope you have enjoyed the presentation and learned something. And feel free to reach out with questions or comments. If you mail, it will not be an avatar that replies. I promise.